Before we begin, a quick and important disclaimer. The content provided in this video is for educational and entertainment purposes only and does not constitute legal, financial, or professional advice. The American legal system is complex, and laws regarding domestic relations vary significantly by state and jurisdiction. Watching this video does not create an attorney-client relationship. You should not act or refrain from acting based on any information presented here without seeking the counsel of a licensed attorney in your specific area. Always conduct your own due diligence and consult with a qualified professional regarding your unique circumstances. Every single minute in the United States, approximately 2 couples file for divorce. That is nearly 3,000 filings every single day. While we often focus on the emotional toll or the social impact of these breakups, there is a massive multi-billion-dollar engine humming beneath the surface that few people truly understand until they are forced into it. It is an industry built on the wreckage of the American dream, where a single signature can trigger a decade of litigation, and where the average cost of a contested divorce can spiral upward of $15,000 to $30,000 per person. We are talking about the American divorce attorney industry, a sector that thrives on conflict, thrives on complexity, and remains one of the most recession-proof businesses in the United States. Today, we are pulling back the curtain on how this machine actually functions. We are looking at why some cases cost the price of a used sedan while others cost the price of a luxury home in the suburbs, and we are going to explore the specific mechanics of billable hours, retainer fees, and the strategic maneuvers that can either settle a case in months or drag it out for years. This is not just about law, it is about the business of heartbreak. For the American viewer today, understanding this industry is a matter of self-defense. Whether you are currently navigating a separation, supporting a friend through one, or simply interested in the economic underpinnings of our legal system, the problem we are solving today is the information asymmetry that exists between the client and the firm. Most people walk into a law office with no idea how the billing cycle works, how a paralegal's time is leveraged against their deposit, or how the discovery process is used as a financial tool. By the end of this deep dive, you will understand the historical trends of the industry, the structural incentives that drive legal strategy, and the logistical reality of how the American family court system operates in the modern era. To understand where the industry stands today, we have to look at the transition from fault-based to no-fault divorce. Historically, in the United States, you had to prove a specific reason to end a marriage, such as adultery, cruelty, or abandonment. This created a specific type of legal industry focused on private investigators and high-stakes evidentiary hearings. However, with the 1969 passage of no-fault divorce laws in California, which then rippled across the country, the industry underwent a fundamental shift. The focus moved from proving guilt to the equitable distribution of assets and the determination of parental responsibilities. This shift did not make the industry smaller. It made it more administrative and, in many ways, more expensive because the focus turned to the valuation of complex assets like 401ks, stock options, and real estate portfolios. The modern divorce attorney industry is estimated to generate over $11 billion in annual revenue. This revenue is driven by a diverse ecosystem of practitioners, ranging from solo practitioners in small towns to massive, multi-state family law firms that employ hundreds of associates. At the top of this pyramid are the boutique firms in major metropolitan areas like New York, Los Angeles, and Chicago, where hourly rates for a senior partner can exceed $1,000 per hour. In these high-net-worth cases, the legal team often expands beyond just the attorney to include forensic accountants, vocational experts, and child custody evaluators. Let's look at the step-by-step breakdown of how a typical engagement begins. It starts with the initial consultation. While some firms offer free consultations as a marketing hook, many high-end firms charge their full hourly rate for this first meeting. This is the first filter of the industry. The attorney uses this time to assess the complexity of the marital estate and the level of conflict between the parties. If there is a high degree of conflict regarding children or a significant disparity in income, the attorney views this as a high-resource case. Following the consultation, the client is presented with a retainer agreement. This is a crucial document that acts as a down payment for future services. In the American market, retainers can range from $2,000 for a simple uncontested filing to $50,000 or more for a complex litigation case involving business valuations. The retainer is held in an IOLTA account or an interest on lawyer's trust account. As the attorney and their staff work on the case, they bill against this fund. This is where the concept of the billable hour becomes the primary driver of the industry's economics. Most firms bill in increments of 6 minutes, or 1/10 of an hour. Every email, every phone call, and every minute spent drafting a motion is logged. For example, if an attorney with a $400 hourly rate spends 12 minutes reading an email from the opposing counsel and another 12 minutes drafting a reply, the client has just spent $80. When you multiply this across hundreds of communications throughout a year-long case, you begin to see why the costs escalate so rapidly. The industry also relies heavily on the leverage of non-attorney staff. Paralegals and legal assistants perform much of the heavy lifting, such as gathering financial records and preparing initial drafts of disclosures. While their hourly rates are lower, often between $100 and $200 per hour, their involvement is constant. A well-run firm uses this tiered billing structure to maximize efficiency, but for the client, it means multiple people are billing for different aspects of the same task. For instance, if a paralegal organizes a box of tax returns, and the attorney then spends an hour reviewing the paralegal's summary, the client is paying for both sets of time. Beyond the internal mechanics of the law firm, the industry is deeply intertwined with third-party experts. In a significant percentage of American divorces, the valuation of the family home is just the beginning. The attorney industry acts as a gateway for other professional services. Forensic accountants are brought in to perform a lifestyle analysis or to search for hidden assets. These experts often charge their own retainers and hourly rates, sometimes rivaling the costs of the attorneys themselves. According to historical trends in high-conflict litigation, these expert fees can represent 30 to 40% of the total legal spend. The litigation process itself is designed in a way that encourages extensive billing. The discovery phase is the longest and most expensive part of the process. This is the formal exchange of information where each side has the right to request every bank statement, credit card bill, and text message relevant to the marriage. In the digital age, this has evolved into e-discovery, requiring specialized software to sift through thousands of pages of digital data. Attorneys often spend dozens of hours in depositions, which are out-of-court testimonies under oath. A single day of depositions can cost a client several $1,000s when you account for the attorney's prep time, the actual time spent in the room, the court reporter's fee, and the cost of the transcript. The American divorce attorney industry is also shaped by the specific statutes of each state. In community property states like Texas or California, the law generally dictates a 50-50 split of marital assets, which in theory should simplify things. However, the conflict often shifts to what is considered separate versus marital property. In equitable distribution states, the court has more discretion to divide property based on what is fair, which can lead to even more litigation as each side argues for a larger share based on their contributions to the marriage or their future needs. This legal nuance ensures that the demand for specialized legal expertise remains high, regardless of the simplicity of the underlying law. As we move forward in this deep dive, we will examine how the industry is being disrupted by technology, the rise of collaborative law, and the economic realities of the courthouse backlog. But to understand the power of the divorce attorney, one must first understand that they are operating within a system designed for conflict resolution through exhaustion, either emotional or financial. The industry is not just a service. It is a complex infrastructure that manages the transition of wealth and parental rights across the American landscape. To understand the sheer scale of the administrative machine that powers the American divorce attorney industry in 2026, we have to look at the transition from the initial filing to the grueling phase of discovery. Imagine a character named Michael, a mid-level executive in Chicago with a suburban home, 2 children, and a standard diversified investment portfolio. When Michael's attorney files the initial petition for dissolution of marriage, the industry's clock starts ticking at a rate that would make most small business owners dizzy. The filing fee alone in many jurisdictions has climbed significantly over the last decade, often ranging between $300 and $500 just to open the case file with the clerk of the court. But that is the smallest check Michael will write. Once the petition is served, the legal industry shifts into its most profitable and labor-intensive gear: the mandatory disclosure process. In the United States, transparency is the rule, not the exception. Attorneys use a specific set of tools to ensure every single cent is accounted for. Imagine if Michael is asked to produce every bank statement, credit card slip, mortgage document, and retirement account summary from the last 5 to 7 years. This is not just a request, it is a legal requirement. Historical trends show that the average middle-class divorce involves the processing of over 500 pages of financial documentation. The attorney's office doesn't just receive these files. They must audit them. A junior associate or a senior paralegal will spend dozens of hours cross-referencing Michael's disclosed income against his lifestyle expenses to look for discrepancies. If Michael's monthly expenses are $10,000 but his reported income is only $7,000, the industry triggers a forensic inquiry. This is how a standard case transitions from a simple paperwork filing into a high-stakes investigation. The complexity deepens when we look at the valuation of intangible assets. In 2026, the American workforce is no longer just tied to a weekly paycheck. We have stock options, restricted stock units or RSUs, and complex pension plans. This is where the divorce attorney industry intersects with the world of actuarial science. An attorney will often hire a QDRO specialist, a qualified domestic relations order expert, specifically to handle the division of retirement accounts. These specialists charge separate fees, often ranging from $500 to $2,000 per account, just to draft the order that tells a plan administrator how to split a 401k without triggering massive tax penalties. For a client like Michael, who might have a 401k from a current employer and 2 rolled over IRAs from previous jobs, the administrative costs of simply dividing what he already owns can exceed $5,000 before a single minute is spent in a courtroom. Let's talk about the specific logistical burden of the temporary orders hearing. In many American jurisdictions, there is a massive gap between the day you file for divorce and the day your assets are finally divided. This period can last anywhere from 6 months to 2 years. During this time, the industry creates what is known as status quo orders. Attorneys must litigate who stays in the house, who pays the car insurance, and how much temporary child support is paid. This is often more contentious than the final settlement because it sets the tone for the entire case. Imagine if Michael's spouse requests temporary alimony that exceeds Michael's ability to pay, while also maintaining his own separate apartment. The attorneys will spend 10 to 20 billable hours preparing for a hearing that might only last 30 minutes in front of a judge. They are drafting financial affidavits, which are essentially balance sheets of a human life. In these affidavits, every line item is scrutinized. If Michael claims he spends $200 a month on dry cleaning, the opposing attorney will demand receipts. This level of granular detail is the engine that drives the billable hour. Case studies from various states show that the escalation of conflict is often a structural byproduct of the adversarial system. When one attorney sends a demanding letter, the other must respond to protect their client's interests. This back and forth is known as the paper war. In 2026, this has migrated to digital platforms, but the cost remains the same. Every time an attorney logs into a practice management software to read a message from the other side, the meter runs. If Michael and his spouse are fighting over a specific piece of furniture or the holiday schedule for the upcoming year, the cost of the legal time spent debating the issue can quickly exceed the value of the item or the time itself. It is a common historical trend in family law for couples to spend $5,000 in legal fees arguing over a $3,000 asset. Brings us to the role of the guardian ad litem or the custody evaluator. Children are involved and parents cannot agree on a schedule. The industry introduces a third-party neutral. This is often another attorney or a mental health professional appointed by the court but paid for by the parents. In high-conflict cases, a custody evaluation can cost between $10,000 and $30,000. The evaluator conducts interviews, visits homes, and reviews school records. The divorce attorneys then spend more time reviewing the evaluator's report, deposing the evaluator, and preparing to challenge or defend the recommendations. This layer of the industry is built on the premise that the best interests of the child require professional intervention, but the financial barrier to this intervention is often immense. The industry also relies on a strategy known as the war of attrition. This is not an official term, but it describes a scenario where one party with more significant financial resources uses the legal process to exhaust the other party's funds. By filing multiple motions, requesting excessive discovery, and delaying hearings, the wealthier party can force a settlement simply because the other person can no longer afford to pay their attorney. This is why the initial retainer is so critical. If a client cannot replenish their retainer, the attorney may move to withdraw from the case, leaving the individual to represent themselves against a professional firm. This creates a massive disparity in potential outcomes, as the self-represented litigant is often unfamiliar with the rules of evidence or the specific phrasing required for a domestic relations order to be enforceable. Furthermore, we must consider the geography of the industry. A divorce attorney in downtown Manhattan or the Silicon Valley operates in a completely different economic reality than one in rural Ohio. In high cost of living areas, the overhead for a law firm, including office space, malpractice insurance, and specialized research databases, is passed directly to the client. In 2026, many firms have moved to a hybrid model, but the premium for a prestigious firm address remains. This prestige is often marketed as a necessity for high-stakes cases, creating a psychological tier system where clients feel they must hire the most expensive firm available to ensure they are not outgunned. But what happens when the paper war reaches its breaking point? What happens when the bank accounts are drained, the forensic audits are complete, and both parties are still standing their ground? This is where the industry shifts from the office to the courthouse, and the stakes transform from financial to existential. As we prepare to look at the next phase, we have to ask, how does the American court system actually decide who gets the house, who gets the kids, and who gets the debt when the evidence is awash? And more importantly, how do attorneys prepare their clients for the moment a judge, a complete stranger, takes control of their entire future? The answers lie in the mechanics of the trial itself, a stage of the process that only 5% of cases reach, yet it dictates 100% of the industry's strategy. In the next part, we examine the anatomy of the courtroom showdown and the hidden influence of judicial discretion. To understand why the courtroom showdown is the most feared and expensive phase of the American divorce attorney industry, we have to look at the sheer logistical weight of preparing for a full-scale trial in 2026. While the vast majority of cases in the United States settle before reaching this point, the entire industry operates on a concept called the shadow of the law. Every letter written, every discovery request filed, and every mediation session held is done with the underlying threat that if an agreement is not reached, a judge will decide. This threat is the primary leverage used by attorneys to push clients toward settlement. But when that leverage fails, the financial gates open wide. Imagine a character named Sarah, a successful entrepreneur in Austin, Texas. Sarah and her spouse have been in litigation for 18 months. They have reached an impasse over the valuation of Sarah's tech startup and a complex custody arrangement for their 3 children. Because they cannot agree, their case is set for a 3-day trial. In the world of family law, a 3-day trial does not just cost 3 days of an attorney's time. It represents hundreds of hours of trial preparation. In 2026, the preparation to trial ratio in the industry is often cited as 10-to-1. For every hour spent in front of the judge, Sarah's legal team spends 10 hours preparing exhibits, drafting opening statements, and conducting mock cross-examinations of expert witnesses. The first major expense in this phase is the trial notebook. This is a massive compilation of every piece of evidence intended for the court. In Sarah's case, this includes 5 years of business tax returns, thousands of text messages, school records, and forensic accounting reports. Each document must be Bates-stamped, organized, and shared with the opposing side according to strict rules of civil procedure. If an attorney fails to include a document in the exhibit list by the court-mandated deadline, that evidence may be excluded entirely, potentially altering the potential outcomes of the property division. This administrative task alone can cost Sarah $5,000 to $10,000 in paralegal and associate time before she even walks through the courthouse doors. Once the trial begins, the atmosphere shifts from administrative to adversarial. In the United States, family law trials are bench trials, meaning there is no jury. One individual, the judge, holds the power to redistribute Sarah's wealth and dictate her parental schedule. This is where the industry's reliance on judicial discretion becomes apparent. Every judge has a reputation, a history of rulings, and specific preferences for how evidence is presented. Sarah's attorney is not just arguing the law. They are performing for a specific audience of one. Historical trends suggest that judges often rely on local rules and their own past precedents, which is why local counsel, attorneys who practice in that specific courthouse every day, command such a premium. They know which arguments will resonate with Judge X and which will infuriate Judge Y. The anatomy of the trial starts with the opening statement. This is the roadmap. Each attorney lays out their theory of the case. For Sarah's spouse, the theory might be that Sarah was a workaholic who neglected the family to build her startup, and therefore the spouse deserves a larger share of the marital estate to compensate for their domestic contributions. For Sarah, the theory is that her startup was founded with separate property funds, and that her spouse's involvement was negligible. These narratives are backed by the introduction of evidence through witness testimony. This leads to the most high-stakes portion of the industry's service, the cross-examination. Imagine Sarah on the witness stand. The opposing attorney is not just asking questions. They are attempting to impeach her credibility. They might bring up a single email from 4 years ago where Sarah complained about her children's school, using it as evidence that she is not the primary caregiver. This psychological pressure is a deliberate tool. The industry knows that most clients find the witness stand to be a traumatic experience. Attorneys often use this pressure to force a courthouse step settlement, a last-minute deal signed in the hallway just minutes before the trial is scheduled to begin. Beyond the attorneys, the courtroom is filled with expensive professionals. The forensic accountant Sarah hired to value her business must now testify as an expert witness. In 2026, an expert witness can charge between $500 and $800 per hour just to sit in the gallery waiting for their turn to speak. If the trial runs long or the previous witness takes more time than expected, Sarah is paying for that expert to simply wait. Additionally, there are the costs of the court reporter, who creates the official transcript. In many jurisdictions, if you want a daily transcript, a written record of what was said each day to help prepare for the next morning, you are paying a premium that can reach over $1,000 per day. The role of the guardian ad litem also reaches its peak here. They take the stand to give their recommendation on custody. In the American legal system, the judge gives significant weight to this neutral party. If the guardian ad litem recommends a 50-50 split but Sarah is fighting for primary custody, her attorney must spend hours cross-examining the very person the judge appointed to be the eyes and ears of the court. This creates a circular economy where the parents are paying for a professional to investigate them, and then paying their own attorneys to fight that professional's findings. One of the most misunderstood aspects of the industry is the final judgment or decree. After the trial ends, the judge does not usually rule immediately. They take the case under advisement. This period can last weeks or even months. During this time, the attorneys are still billing. They must draft proposed findings of fact and conclusions of law. These are lengthy documents that tell the judge exactly how the final order should be written based on the evidence presented. If the judge agrees with Sarah's attorney, they might sign the proposed order with minimal changes. This is the final stage of the industry's craftsmanship, turning a 3-day battle into a legally binding document that will govern Sarah's life for the next decade. However, the industry does not always stop at the final decree. There is the post-judgment phase. Historical trends show that about 20% of contested divorces end up back in court within 3 years for modifications or enforcement actions. If a spouse fails to pay the court-ordered alimony or refuses to follow the custody schedule, the legal machine starts up again. This is known as a contempt of court proceeding. For the attorneys, this represents a recurring revenue stream. For the clients, it represents a realization that the divorce was not an event, but the beginning of a lifelong interaction with the legal system. The financial impact of a full trial is often the single greatest wealth transfer event in a person's life. Between the attorney fees, expert witness costs, court fees, and the loss of productivity from taking weeks off work, a trial can easily consume 20 to 30% of a couple's total net worth. This is why the industry has seen a massive push toward alternative dispute resolution. But what happens when the legal system tries to fix its own cost problem? In 2026, we are seeing the rise of a parallel industry, the private mediation and arbitration sector. As we look deeper into the architecture of American divorce, we must ask, is there a way to bypass the courtroom entirely without sacrificing legal protection? The next phase of our masterclass explores the world of collaborative law and the rise of the shadow judiciary, where wealthy couples are now hiring their own private judges to settle their disputes in office buildings instead of public courthouses. But as we will see, this luxury version of divorce comes with its own hidden costs and strategic pitfalls. We are moving from the public square to the private boardroom to see how the elite navigate the same heartbreak at a much higher price point. The shift from public litigation to the private boardroom marks the emergence of the premium tier within the American divorce attorney industry: collaborative law and private adjudication. In 2026, for high-net-worth individuals, the traditional courthouse is often viewed as a liability rather than a venue for justice. Public records mean public exposure, and for a business owner or a public figure, the disclosure of a sensitive balance sheet or a controversial text message can have repercussions far beyond the legal settlement. This has birthed the collaborative divorce model, a structured process where both parties and their attorneys sign a formal contract, a participation agreement, committing to stay out of court. Imagine a character named David, a high-level partner in a Seattle-based venture capital firm. David and his spouse have a combined marital estate exceeding $50 million. In a traditional litigation setting, David would be terrified of the discovery process becoming part of the public record. Instead, he opts for a collaborative law team. This is not just two lawyers in a room. It is a multidisciplinary squad. The industry here functions as a project management firm. The team typically includes two collaborative attorneys, a neutral financial professional, and a divorce coach, usually a mental health professional tasked with managing the high emotional volatility that often derails financial negotiations. The economic structure of collaborative law is unique because of the disqualification clause. This is the industry's most potent structural incentive. If the collaborative process fails and either party decides to go to court, both attorneys are contractually barred from representing their clients in that litigation. The clients must fire their entire teams and start from scratch with new, expensive litigation firms. For David, this means that if he walks away from the table, he loses the $50,000 he has already invested in his collaborative team and must pay another $50,000 retainer to a trial lawyer. This creates a financial sunk cost that keeps both parties at the negotiating table, even when the sessions become heated. Within these private sessions, the role of the neutral financial professional is paramount. Unlike a forensic accountant in a trial who is hired to find dirt on the other spouse, the collaborative neutral is tasked with creating a single verified data set that both sides trust. They build a comprehensive spreadsheet of all assets, from the valuation of David's carried interest in his venture funds to the projected future value of the couple's real estate holdings. Historical trends indicate that while the upfront cost of hiring a neutral is high, often $10,000 to $15,000, it can significantly reduce the billable hours spent by attorneys arguing over which bank statement is the most recent. By having one professional do the math for both sides, the industry shifts from an adversarial valuation to a joint problem-solving exercise. However, even the collaborative model has its limitations, which brings us to the rise of the shadow judiciary, private judging. In many states, including California and Florida, the law allows for a process known as a private reference. This is where the parties pay for a retired judge to act as their private arbitrator. Imagine David and his spouse realize they cannot agree on the final distribution of a specific overseas asset. Rather than waiting 18 months for a slot on the overburdened public court docket, they hire a retired superior court judge. This judge charges an hourly rate often exceeding $800. They rent a conference room in a luxury office building, and the trial happens there. The logistics of private judging are a masterclass in efficiency and exclusivity. In a public courthouse, you might wait 4 hours in a hallway just to have your case called, and you are paying your attorney $400 an hour for that wait time. In the private sector, the judge is ready the moment you walk in. There are no other cases on the docket. The industry markets this as a cost-saving measure in the long run, as it eliminates the billing for dead time in the courthouse. Furthermore, the private judge can offer a level of expertise that a randomly assigned public judge might lack. If David's case involves complex maritime law or international tax treaties, he can select a private judge who specialized in those fields during their time on the bench. Case studies from 2026 show that the use of private judges has increased by nearly 30% in major metropolitan hubs. But this creates a tiered system of justice. While the wealthy pay for speed and expertise, the public system becomes more congested for everyone else. For the attorneys, the private judge model is a dream. It allows them to control the environment, avoid the unpredictability of a public courtroom, and ensure their clients remain comfortable. For the client, the potential outcomes are more predictable, but the cost of the judge's time, often $20,000 to $30,000 for a week of hearings, is an added layer of expense that most middle-class Americans cannot fathom. Beyond the legal and financial professionals, this elite sector of the industry has integrated luxury concierge services. There are now firms that specialize solely in the logistical transition of a divorce. They handle the inventorying of art collections, the appraisal of high-end wine cellars, and the physical separation of a shared household. If David and his spouse have 3 homes, a concierge firm will be hired to duplicate the children's rooms in each location down to the specific brand of toothpaste, ensuring a seamless transition. The attorneys oversee these vendors, often taking a coordination fee or billing for the time spent communicating with them. This expands the divorce industry from a legal service into a comprehensive lifestyle management sector. Yet, even in the most civilized private boardrooms, the core issue of the American divorce remains: the distribution of a finite pool of resources. Whether it is a $10,000 savings account or a $10 million pension, the underlying tension is the same. The industry survives on this tension. The more complex the asset, the more professionals are required to touch it. In 2026, we are seeing a massive surge in the complexity of marital estates due to the globalization of labor and the rise of decentralized finance. Imagine if David had invested significantly in a private equity fund that holds assets in multiple jurisdictions, or if his spouse had a significant portfolio of digital assets that are difficult to track and value. This leads us to the next frontier of the industry, the technological arms race. As clients find new ways to store and hide wealth, attorneys and forensic experts are deploying increasingly sophisticated tools to find it. The battle is moving from the file cabinet to the blockchain and the encrypted server. How does an attorney subpoena a decentralized autonomous organization? How do they prove the existence of a hidden cold wallet in a jurisdiction that doesn't recognize American court orders? The answers are changing the way family law is practiced at the highest levels. In the next part, we dive into the world of electronic discovery and the specialized teams tasked with uncovering the digital breadcrumbs of a modern marriage. We will look at how a single deleted message or a forgotten transaction on an app can become the smoking gun that changes a settlement from 5 figures to 7. The digital hunt is on, and the specialists are charging by the minute. The digital hunt within the American divorce attorney industry has evolved into a high-stakes discipline known as computer forensic discovery, or e-discovery. In 2026, the paper trail has been almost entirely replaced by a data trail. To understand how this works, imagine a character named James, a senior software architect in San Jose. James is going through a contested divorce and claims that his primary assets are his salary and a modest savings account. However, his spouse's legal team suspects there is more beneath the surface. In the old days, they would look through a filing cabinet. Today, they hire a digital forensic examiner. This examiner is the industry's secret weapon. They do not just look at open files. They look at metadata, deleted fragments, and application logs. In the United States, the legal standard for discovery includes all electronically stored information. This means that every device James has touched, his smartphone, his laptop, his smart home hub, and even his integrated vehicle system, is subject to a forensic image. A forensic image is a bit-for-bit copy of a hard drive that captures everything, including data that the user thinks they have erased. When a file is deleted, the operating system simply marks that space as available for new data, but the original information often remains until it is overwritten. The examiner uses specialized software like Encase or Celebrite to recover these ghosts of data. Consider the role of geolocation data in the modern divorce. Attorneys now routinely subpoena records from fitness tracking apps, ride-sharing services, and even toll booth transponders. If James claims he was working late at the office every Tuesday for a year to justify a decrease in his domestic responsibilities, but his Apple Watch data shows him at a different residential address across town, his credibility is decimated. In the American legal system, credibility is the currency of the courtroom. Once an attorney proves a client lied about their location, the judge is statistically more likely to doubt their testimony regarding their hidden bank accounts or the valuation of their business. The industry has also seen a massive surge in the forensic audit of social media. This goes far beyond looking at public posts. In 2026, attorneys use specialized crawlers to capture a permanent record of a spouse's digital footprint. They look for evidence of a lifestyle that contradicts financial affidavits. If a spouse claims they have no money for child support, but is tagged in photos at a luxury resort in the Maldives, or is seen wearing a new $5,000 watch, the attorney will use those images as exhibits in a motion for contempt. The cost of this digital surveillance is significant. A thorough social media audit can cost between $3,000 and $7,000, yet historical trends show it is one of the most effective ways to secure a favorable settlement during mediation. But the real frontier of the 2026 divorce industry is the discovery of decentralized assets. Cryptocurrency, non-fungible tokens, and decentralized finance protocols have created a complex layer of anonymity that traditional banking laws struggle to pierce. Imagine if James had been slowly moving marital funds into a hardware wallet over 3 years. A standard subpoena to a bank like Chase or Wells Fargo would show the outbound transfer, but it would not show where the money went or its current value. This has birthed a specialized subsector of the industry, blockchain forensics. Attorneys now collaborate with on-chain analysts who use tools like Chainalysis to track the movement of funds across the ledger. They look for hops between wallets and interactions with centralized exchanges where Know Your Customer or KYC rules apply. If the analyst can link a specific wallet to James through an old email or a phone number used for an exchange login, the court can order James to produce the private keys or provide an accounting of the assets. If he refuses, the judge can use a legal mechanism called an adverse inference. This means the court will simply assume the hidden assets exist and award the other spouse a larger share of the visible assets, such as the family home or the retirement accounts, to offset the value of the hidden crypto. Step by step, the e-discovery process follows a strict protocol to ensure the evidence is admissible. First is the preservation letter. As soon as a divorce is contemplated, an attorney sends a formal notice to the other side demanding that no data be deleted and no devices be wiped. If James were to use a program like CCleaner or a factory reset on his phone after receiving this letter, he could face sanctions for spoliation of evidence. Spoliation is a serious offense in American family law. It can result in the offending party being ordered to pay the other side's entire legal bill, or even being held in criminal contempt. Next is the collection phase, where the digital examiner physically or remotely accesses the devices to create the forensic copies. Then comes the analysis, where keyword searches are performed. Attorneys do not just read every text. They search for terms like bank, transfer, password, island, or the names of suspected paramours. This phase is highly automated, but requires an attorney to review the hits for attorney-client privilege. You cannot use a text message between a spouse and their own lawyer as evidence, so the industry employs privilege logs to document what is being withheld. The sheer volume of data is staggering. In a 2026 case study, a single divorce involving a mid-level executive resulted in the processing of over 4 terabytes of data. The billable hours for the paralegals and junior associates to categorize this data reached $40,000 before the case even made it to a settlement conference. This is why many firms now utilize artificial intelligence for document review. AI can identify patterns in financial spending or tone shifts in communication that a human might miss. For example, the AI might flag that James started using an encrypted messaging app like Signal exactly 6 months before the filing, which suggests a premeditated attempt to hide communications. However, the digital arms race is not just about finding money. It is about the intersection of privacy and property. In many states, if a spouse accesses the other's computer or email without permission, they may be violating the Electronic Communications Privacy Act or state-level computer fraud laws. The divorce attorney must navigate this minefield carefully. If the evidence is obtained illegally, not only is it inadmissible in court, but the attorney themselves could face disciplinary action. This is why the industry relies on formal discovery requests rather than DIY hacking. It is a slow, methodical, and incredibly expensive process of legal maneuvering. As the digital hunt concludes, the results are compiled into a comprehensive financial disclosure. This document becomes the foundation for the final division of the marital estate. But even with all the data in the world, one question remains. How do you divide a life that is spread across multiple countries, various tax brackets, and complex legal entities? The digital trail has led us to the vault, but opening it requires a different kind of expertise. In the next part of our masterclass, we move into the world of international jurisdiction and the complexities of the global divorce. We will explore what happens when an American couple owns property in France, has a business in Singapore, and holds a trust in the Cayman Islands. We are entering the realm of the international family law specialist, where the conflict is no longer just between two people, but between two or more competing legal systems. How do you stop a spouse from fleeing to a non-extradition country with the marital fortune? The answer involves international treaties, emergency injunctions, and a high-stakes game of legal chess that spans the globe. The complexity of the American divorce attorney industry reaches its zenith when the boundaries of the United States are crossed, entering the high-stakes world of international family law. In 2026, with the globalization of the workforce and the rise of remote digital nomads, it is increasingly common for a marital estate to be scattered across multiple continents. This geographic fragmentation creates a phenomenon known as forum shopping. This is the strategic process where an attorney evaluates which country's legal system will offer the most favorable potential outcomes for their client. For example, some jurisdictions are historically more generous with alimony, while others strictly adhere to the separation of premarital assets, regardless of the length of the marriage. Imagine a character named Robert, a senior executive for a multinational energy firm based in Houston, Texas. Robert has spent the last decade moving between London, Dubai, and Singapore. He and his spouse, who is a French national, own a primary residence in Texas, a vacation villa in Provence, and a significant investment portfolio held in a Swiss bank account. When the marriage breaks down, the first question Robert's attorney asks isn't how to divide the assets, but rather, where should we file? In the United States, once a divorce is filed in a specific state, that court gains jurisdiction over the parties, but enforcing an American court order on a villa in France or a bank account in Zurich is a logistical labyrinth that requires a network of international legal experts. The industry handles this through a mechanism called comity. Comity is the legal principle where one country's court recognizes and enforces the judicial decisions of another country. However, this is not a universal rule. The United States is not a party to a comprehensive international treaty for the recognition of foreign matrimonial judgments, which means every single asset in a foreign country must be handled with a surgical level of detail. Robert's American attorney will often act as a lead counsel or a legal quarterback, hiring local solicitors in London and advocates in Singapore to ensure that the strategy in Texas does not accidentally trigger a negative tax event or a loss of property rights abroad. One of the most intense aspects of international divorce is the race to the courthouse. In many international scenarios, the first person to file in a valid jurisdiction determines which country's laws will apply. Imagine if Robert's spouse files for divorce in England, where the courts have a historical trend of being very generous toward the financially dependent spouse, while Robert wants to file in Texas, which follows community property rules. This results in an anti-suit injunction battle. Robert's attorney might ask a Texas judge to order the spouse to stop the proceedings in London. The legal fees for this jurisdictional tug-of-war can easily exceed $100,000 before the parties even begin to discuss the actual division of their property. Furthermore, we must address the critical issue of international parental-child abduction. In 2026, the ease of international travel makes this a significant concern for divorce attorneys. If one parent takes the children to a foreign country without the other parent's consent, the industry relies on a treaty known as the 1980 Hague Convention on the Civil Aspects of International Child Abduction. This is an administrative framework designed to return children to their country of habitual residence. Attorneys specializing in Hague cases operate in a high-pressure environment where timing is everything. They must file a petition with the central authority and work with the Department of State to secure the return of the children. Case studies show that while the Hague Convention is effective among signatory nations, if a parent flees to a non-signatory country, the legal hurdles become nearly insurmountable, often requiring diplomatic intervention alongside private security and recovery teams. Step by step, the international asset division process involves the issuance of letters rogatory. These are formal requests from an American court to a foreign court asking for judicial assistance, such as the taking of testimony or the production of documents. If Robert has hidden funds in a shell company in the British Virgin Islands, his spouse's attorney will use these letters to attempt to pierce the corporate veil. This is a slow and expensive process, often taking 6 months to a year just to get a response. In the meantime, the industry uses Mariva injunctions, which are freezing orders that prevent a party from moving or dissipating assets located anywhere in the world. For the wealthy client, this means their entire global liquidity can be locked down by a single court order, creating massive leverage for the spouse seeking a settlement. The tax implications of these global moves are equally complex. In 2026, the Internal Revenue Service maintains strict reporting requirements for foreign bank accounts, known as FBAR, and the Foreign Account Tax Compliance Act, or FATCA. A divorce attorney must work closely with International Tax Counsel to ensure that the division of a Swiss account or a French villa doesn't result in a 30% withholding tax or a massive capital gains bill that eats the entire value of the asset. Historical trends indicate that many international settlements are actually driven more by tax optimization than by the legal merits of the case itself. The attorneys are essentially looking for the path of least resistance from the perspective of the tax authorities in multiple nations. Even for the middle class, international elements are becoming more common. Consider a couple where one spouse is an immigrant on an H-1B visa. The divorce attorney must now consider the immigration status of their client. In the United States, a divorce can potentially impact a person's ability to remain in the country if their residency is tied to their spouse's status. The industry here overlaps with immigration law, where attorneys must strategically timing the final decree to ensure the client has time to transition to a different visa category. This is a layer of responsibility that adds significant weight to the attorney's role. A mistake in the timing of a filing could result in a client's deportation, separating them from their children and their livelihood. As we navigate the complexities of international borders and diverse legal systems, the American divorce attorney industry proves itself to be a truly global enterprise. The experts at this level are not just lawyers. They are international strategists, tax navigators, and diplomats. They are managing the friction between the laws of the United States and the laws of the world. But as we look at these high-level maneuvers, we must return to a fundamental question that affects every single divorce, regardless of the size of the bank account. How does the industry handle the human element? The paper trails, the forensic audits, and the international treaties are all tools used to manage people in their most vulnerable states. But as the legal battles grow more complex, a new trend is emerging in the United States: the rise of artificial intelligence and automated legal services designed to bypass the traditional attorney entirely. Can a machine really replace a seasoned litigator when it comes to the nuances of a custody battle or the valuation of a startup? In the next part, we dive into the Silicon Valley of family law, where algorithms are being trained to predict judicial rulings and automated platforms are promising a divorce for the price of a smartphone. But as we will discover, the human touch in the law is not so easily automated, and the risks of a DIY digital divorce can be far higher than the fees of a traditional firm. The Silicon Valley of family law has officially arrived in 2026, and it is fundamentally reshaping how the American public interacts with the legal system. As traditional billable hours continue to climb, a new sector of the industry has emerged: legal technology, or law tech, specifically tailored for domestic relations. We are seeing a massive surge in automated platforms that aim to commoditize the divorce process. Imagine a character named Mark, a graphic designer in Denver. Mark and his spouse have decided to end their marriage amicably. They have no children and a relatively simple estate consisting of a rented apartment and 2 separate bank accounts. Instead of hiring a traditional attorney for a $5,000 retainer, Mark logs into an AI-driven platform that advertises a complete divorce package for $900. This is the dawn of the DIY digital divorce. These platforms use logic branching algorithms to guide users through the complex web of state-specific forms. In the United States, every county can have its own unique filing requirements. Mark's platform uses a series of prompts to gather data, essentially acting as a digital paralegal. It asks for his income, his assets, and his preferred division of property, then automatically populates the required decree of dissolution. Historical trends show that for the roughly 30% of American couples who are truly in agreement on every single issue, these automated services can be a highly efficient alternative to the traditional firm model. They eliminate the middleman and provide a structured path through the bureaucratic red tape. However, the industry is discovering that there is a massive gap between generating a document and receiving sound legal counsel. This is where the risks of automation become apparent. Imagine if Mark's spouse has a small pension from a job she held 5 years ago. The AI platform might ask if there are retirement accounts, but it may not explain the long-term value of a survivor benefit or the specific language required by a plan administrator to actually divide that pension. Without the human touch of a seasoned attorney, Mark might sign a document that is legally binding, but financially devastating 10 years down the line. Case studies from early 2026 indicate a rising number of post-decree litigation cases where individuals are suing to set aside agreements made through automated platforms due to mutual mistakes or a lack of informed consent. Beyond document generation, the industry is integrating predictive analytics. This is a tool used by top-tier law firms to gain a competitive edge. By feeding decades of judicial rulings into a machine learning model, attorneys can now calculate the statistical probability of a specific outcome in front of a specific judge. If Mark's case were to go to trial, his attorney could use these analytics to determine that Judge Anderson in Denver grants primary custody to the father in only 15% of contested cases, but is highly likely to award permanent alimony in marriages lasting over 10 years. This data allows the attorney to advise Mark on whether to settle or fight, based on hard numbers, rather than just gut feeling. This is the monetization of judicial behavior. The role of the divorce attorney is also being augmented by AI-powered communication monitors. In high-conflict cases, communication between ex-spouses is often the primary source of legal friction. New apps, often court-mandated in 2026, use sentiment analysis to flag aggressive or harassing language in real time. If Mark tries to send an angry text message to his spouse at 2 a.m., The app might block the message or warn him that the tone of his communication could be used as evidence of his inability to co-parent. The attorney's role in this scenario shifts from being a shield to being a data manager, reviewing the app's reports to build a case for or against a change in the parenting schedule. We also have to consider the emergence of the virtual law firm. By 2026, the traditional mahogany desk office is becoming a relic for all but the most elite firms. Many family law practitioners have moved entirely to the cloud. This reduces overhead and allows for lower hourly rates, but it changes the nature of the attorney-client relationship. Clients no longer meet their lawyers in person. They communicate via encrypted video calls and digital portals. This has expanded the reach of the industry, allowing a top-tier attorney in a major city to represent a client in a rural area that lacks specialized legal expertise. But it also raises concerns about the security of sensitive client data. Cyberattacks on law firms are at an all-time high, and the divorce industry, with its treasure trove of financial and personal secrets, is a primary target. Step by step, the integration of technology follows a specific trajectory. First is the digitization of records, where everything moves to a secure cloud server. Second is the automation of routine tasks, like drafting simple motions or calculating child support, based on state guidelines. Third is the deployment of AI for complex analysis, such as searching through thousands of pages of discovery for hidden patterns. The final stage, which we are just beginning to see in 2026, is the use of AI for dispute resolution. Some platforms are now testing blind bidding modules for property division. Mark and his spouse each enter the lowest amount they are willing to accept for an asset, and the AI finds the midpoint, creating a settlement without either party ever speaking to the other. This technological evolution is creating a bifurcation in the market. On one hand, you have the low-cost, high-volume automated services that cater to the general public. On the other, you have the high-touch, AI-augmented boutique firms that use technology as a weapon for their wealthy clients. The middle-class client is often caught in the middle, trying to decide if they should risk a DIY approach or commit to the financial burden of a full-service firm. Historical trends suggest that as technology makes the law more accessible, it also makes it more complex, as the sheer amount of data that can be analyzed in a divorce continues to grow exponentially. But as the machines take over the paperwork and the data analysis, a core human element remains untouched: the concept of fault and the emotional volatility of the breakup. No algorithm can truly account for the spite, the grief, or the desire for vindication that drives so many divorce cases. In the American legal system, the transition from no-fault laws was intended to reduce conflict, but the industry has found that conflict simply relocates to other areas, such as the division of household items or the minutiae of the holiday schedule. This leads us to a critical crossroad in the industry's evolution. As we look toward the future of the American divorce attorney, we must ask: if the paperwork is automated and the outcomes are predicted by data, what is left for the lawyer to do? The answer lies in the art of negotiation and the management of human crisis. But there is a darker side to this evolution, a side where the legal system is used not to resolve conflict, but to amplify it for strategic gain. In the next part, we will explore the controversial world of silver bullet tactics and the weaponization of the legal process. We are moving into the shadows of the industry, where the goal isn't just a fair settlement, but the total tactical neutralization of the opposing party. How do the most aggressive firms in the country use the law as a sword? And what can a person do when they find themselves in the crosshairs? The tactical landscape of the American divorce attorney industry in 2026 includes a controversial and highly aggressive set of maneuvers, often referred to in legal circles as silver bullet tactics. While the legal system is designed to be a shield for the vulnerable, in high-conflict scenarios, the industry has seen the emergence of strategies where the law is used as a proactive weapon to neutralize an opposing party's financial or emotional standing before the case even reaches a substantive hearing. These tactics are built on the exploitation of emergency legal mechanisms, and understanding them is essential to comprehending the full spectrum of the modern family law machine. Imagine a character named Thomas, a successful surgeon in Atlanta. Thomas and his spouse are entering a divorce that has quickly turned bitter. In a traditional scenario, they would argue over assets and custody schedules. However, an aggressive firm might advise a strategy that seeks an immediate, unilateral shift in the power dynamic. This often begins with an ex parte motion. In the United States, an ex parte motion is a request made to the court by one party without prior notice to the other. These are intended for true emergencies, such as the immediate threat of child abduction or physical harm. In the hands of a scorched earth litigator, however, these motions can be used to secure temporary exclusive possession of the marital residence or to freeze every joint bank account Thomas owns before he even knows a divorce has been filed. When a judge signs an emergency order based on one-sided testimony, the impact is instantaneous. Thomas might arrive home from a 12-hour shift at the hospital to find that his key no longer works. A sheriff is serving him with a temporary restraining order, and his access to liquid capital has been severed. This is known as a tactical strike. The goal is not necessarily to win the final trial, but to create a state of shock and financial paralysis that forces the other party to settle on unfavorable terms just to regain access to their life. Historical trends show that while many of these emergency orders are eventually overturned or modified after a full hearing, the initial damage to a person's reputation and credit score can be permanent. Another pillar of the weaponized legal strategy is the strategic use of allegations in child custody disputes. In 2026, the industry has seen a rise in what is colloquially known as the nuclear option, making allegations of unfitness that trigger mandatory investigations by state agencies like Child Protective Services. Once a formal report is made, the family court often feels compelled to take a safety-first approach, which may include supervised visitation or a total suspension of contact until the investigation is complete. For a parent like Thomas, being separated from his children for 60 days while a bureaucratic agency conducts an audit of his home life is a form of psychological warfare. The cost of defending against these allegations is immense, requiring the hiring of criminal defense consultants, child psychologists, and specialized custody litigators. Case studies in the industry highlight the use of the vexatious litigant strategy. This involves the filing of an overwhelming number of motions, discovery requests, and appeals, not to resolve a legal issue, but to drive up the opposing party's legal fees until they can no longer afford to continue the fight. In 2026, with the help of AI-assisted drafting, an aggressive firm can generate dozens of complex legal filings in a fraction of the time it used to take. If Thomas is paying his lawyer $400 an hour to read and respond to 20 different motions regarding the minutiae of his personal life, he may find his entire legal budget exhausted within 3 months. This is a deliberate economic strategy used by the party with more resources to achieve total tactical neutralization. The industry also utilizes the weaponization of the professional network. In some smaller or highly specialized legal markets, a wealthy spouse might conduct initial consultations with all the top-tier divorce attorneys in the city. Under the rules of professional conduct in the United States, an attorney who has a consultation with a potential client and receives confidential information is generally conflicted out of representing the opposing party. This is known as conflict checking out the competition. If Thomas's spouse meets with 5 of the most aggressive firms in Atlanta, Thomas is effectively barred from hiring them, forcing him to choose from second-tier representation or firms that lack the specific expertise needed for his high-net-worth case. Furthermore, we must look at the role of public shaming in 2026 legal tactics. While family court records are often sealed or kept private in certain jurisdictions, the motions themselves can be written with sensationalist language intended to be leaked or discovered by professional peers. An attorney might include unnecessary, non-legal details about a party's private habits or professional failures within a public filing. For a high-profile individual, the threat of this information appearing in a local business journal or on social media serves as a powerful incentive to pay a premium settlement to keep the case out of the public record. This is the intersection of law and reputation management. The tactical use of the contempt power is another layer of the sword. Attorneys will often look for technical violations of a temporary order, such as a parent being 15 minutes late for a custody exchange or accidentally using a joint credit card for a personal purchase, and file a motion for contempt. In some states, a finding of contempt can lead to the payment of the other side's attorney fees, or even brief periods of incarceration. By keeping the opposing party in a constant state of legal jeopardy, an aggressive firm ensures that the individual is too focused on staying out of jail or avoiding fines to focus on the long-term strategic goals of the divorce. Step by step, the response to these tactics requires a specific countermaneuver known as the motion for sanctions. This is where Thomas's attorney asks the court to punish the other side for filing frivolous or bad faith motions. In 2026, judges are increasingly aware of these weaponized strategies and may order the aggressive party to pay $10,000 or $20,000 in immediate penalties. However, the burden of proof for sanctions is high, and the process of proving that a motion was filed in bad faith requires even more billable hours, often creating a cycle of litigation that benefits only the law firms involved. As we examine these shadows, it becomes clear that the American divorce attorney industry is not a monolith of mediation and fair play. There is a segment of the market that operates on the principle that the best way to resolve a conflict is to make it too expensive and painful for the other side to remain in the arena. But what happens when these tactics backfire? What happens when the court realizes it has been used as a tool for harassment? The industry is currently facing a reckoning. New laws are being proposed to curb the abuse of emergency motions and to provide faster relief for those targeted by vexatious litigation. But as the rules change, the tactics evolve. In the next part, we will explore the final economic hurdle of the industry, the collection of fees and the rise of divorce funding. We will look at how third-party investors are now betting on the outcomes of divorces, providing the capital for these legal wars in exchange for a piece of the final settlement. We are moving from the courtroom to the financial markets to see how divorce has become a tradable asset class for Wall Street. The financialization of the American divorce attorney industry has reached a pivotal moment in 2026 with the mainstream adoption of litigation funding, specifically tailored for matrimonial disputes. This is the mechanism where third-party investors, ranging from specialized hedge funds to private equity groups, provide the necessary capital to a spouse who lacks immediate liquidity, but is expected to receive a significant payout at the end of the proceedings. In the industry, this is often described as leveling the playing field, but from a structural perspective, it has turned high-stakes divorce into a tradable asset class. Imagine a character named Jennifer, who lives in a high-value real estate market like Miami. Jennifer has been married for 25 years to a real estate developer whose net worth is tied up in complex LLCs, commercial properties, and future development projects. While the marital estate is valued at $40 million, Jennifer has no direct access to the cash. Her spouse has cut off her credit cards and limited her access to joint accounts as a strategic move to force a lowball settlement. In the past, Jennifer might have been forced to accept a subpar deal simply because she couldn't afford a $50,000 retainer for a top-tier law firm and another $100,000 for forensic accountants. In 2026, Jennifer turns to a divorce funding firm. The process works much like a sophisticated bridge loan. The funding company does not just hand over a check, they conduct an exhaustive due diligence process. Their internal legal and financial teams review the merits of Jennifer's case, the estimated value of the marital assets, and the likelihood of various potential outcomes. If they determine that Jennifer is statistically likely to receive at least $10 million in the final judgment, they will advance her the funds to hire the most aggressive legal team in Florida. In exchange, the funder does not take a monthly interest payment. Instead, they take a percentage of the final settlement or a multiple of the deployed capital. This shift has created a secondary market that influences the primary legal strategy. Because the funder now has a vested interest in the outcome, they often require regular updates on the case's progress. The attorney's role expands to include reporting to these financial stakeholders. This creates a fascinating dynamic. The law firm is being paid by a third party to fight for the client, but the third party's goal is purely a return on investment. Historical trends in 2026 show that cases backed by litigation funding tend to last longer and involve more extensive discovery because the financial barrier to litigation has been removed for the dependent spouse. The industry also utilizes a mechanism known as a charging lien. This is a traditional tool where an attorney secures their unpaid fees against the final judgment or property settlement of the client. However, in the modern era, these liens are often sold or factored to collection agencies that specialize in legal debt. If a client like Jennifer falls behind on her bills, the law firm can continue working while knowing that their fees are secured by the very real estate her spouse is trying to hide. This ensures that the law firm remains incentivized to push the case to the finish line, even if the client is currently broke. Step by step, the economics of this phase involve the valuation of the legal claim itself. Experts in the industry use actuarial tables and local judicial data to put a price tag on a divorce. They look at factors such as the length of the marriage, the age of the parties, the specific state statutes on equitable distribution, and even the health of the spouses. For a hedge fund, a pool of 100 diverse divorce cases represents a diversified portfolio. Some cases will settle quickly for a modest profit, while others will go to a full trial and result in a massive windfall. This is the monetization of domestic conflict on a global scale. We must also examine the role of insurance in the 2026 divorce landscape. We are seeing the emergence of divorce insurance, often marketed as a safeguard for the costs of future litigation. While not yet a standard part of every American household's portfolio, Historical trends among high-earning millennials show an increased interest in policies that pay out a lump sum in the event of a legal separation. The insurance companies, much like the litigation funders, are in the business of predicting risk. They analyze marriage success rates across different demographics and set premiums accordingly. For the divorce attorney, these policies represent a guaranteed source of payment, which often leads to more robust and comprehensive legal strategies right from the beginning of the case. The collection of fees has also moved into the realm of the automated and the aggressive. In 2026, many law firms require clients to sign evergreen retainer agreements. These agreements are linked to the client's bank accounts or credit lines. When the retainer drops below a certain threshold, say $5,000, the firm's billing software automatically pulls a fresh injection of capital from the client's linked account. This ensures that the firm is never working on credit. If the auto-replenish fails, the software automatically generates a motion to withdraw from the case. This algorithmic approach to billing has significantly reduced the amount of pro bono or discounted work in the industry, making the legal system more efficient for the firms but more cold and transactional for the clients. Case studies in 2026 reveal that the financialization of divorce has led to the rise of the divorce consultant, a professional who is neither a lawyer nor an accountant, but a strategist who helps the client navigate the choice between various funding options and legal teams. These consultants often take a flat fee to act as a neutral advisor, helping the client understand that the law firm is a service provider and the litigation funder is an investor. This further fragments the industry into specialized niches, each taking a small percentage of the marital estate. The result of this economic evolution is an industry that is incredibly resilient to economic downturns. In fact, historical trends suggest that divorce filings and the associated legal spending often increase during periods of financial volatility, as spouses fight more fiercely over a shrinking pool of assets. The American divorce attorney industry in 2026 is no longer just a branch of the legal system. It is a vital organ of the financial services sector. It is an engine that redistributes billions of dollars every year, fueled by the intersection of law, finance, and human emotion. But as we reach the pinnacle of this deep dive, we have to look at the final piece of the puzzle. Beyond the money, beyond the tactics, and beyond the technology, there is the final transition, the actual execution of the divorce decree. How does the industry ensure that the house is sold, the accounts are transferred, and the children are moved without a total collapse of the agreement? The final stage is where the paper reality meets the physical world. In the concluding part of our masterclass, we will look at the post-decree landscape and the future of the industry in the 2030s. We will explore the emerging trends of the gray divorce, the impact of radical life extension technologies on marital contracts, and the ultimate question: in a world where everything is automated and financialized, can the American divorce attorney industry ever truly be reformed, or is it destined to grow into an even more pervasive force in our lives? We are going to wrap up this 10-part journey with a look at the systemic changes that could redefine the American family forever. The final phase of the American divorce attorney industry is not the signing of the decree, but the complex and often volatile period known as post-judgment execution and the emerging trends of the 2030s. In 2026, the industry has recognized that a court order is merely a piece of paper until the assets are physically moved and the lifestyle transitions are finalized. This is where the cleanup crew of the legal world takes over. For many Americans, the real friction begins when the adrenaline of the courtroom fades and the logistical reality of uncoupling a shared life sets in. Imagine a character named Elena, a high-earning surgeon in Seattle who has just completed a 2-year legal battle. The judge has signed the final decree, but Elena's work with the legal industry is far from over. She now enters the stage of asset retitling and QDRO implementation. As we touched on earlier, a qualified domestic relations order is the only way to split a retirement account without immediate tax penalties. However, the industry's secret bottleneck is that these orders often take 6 to 9 months to be approved by plan administrators. During this gap, Elena's attorney must stay on retainer to monitor the accounts. If the market shifts or her ex-spouse makes an unauthorized withdrawal, the attorney must file an emergency motion to freeze the funds. This tail end of the process can cost an additional $3,000 to $5,000 in administrative legal fees. The industry is also evolving to handle the gray divorce phenomenon. This refers to the doubling of the divorce rate among Americans over the age of 50. In 2026, these cases represent a massive portion of the market's total revenue because the stakes are strictly financial and involve long-term healthcare planning. For a client like Elena, if she were in her 60s, Her attorney would be coordinating with elder law specialists and Medicare consultants. The legal strategy shifts from custody battles to the division of lifetime Social Security benefits and the valuation of long-term care insurance policies. Historical trends suggest that gray divorces are more likely to involve permanent alimony or complex life insurance trusts to ensure that both parties remain solvent into their 80s. Case studies from the current year show that the industry is also preparing for the impact of radical life extension and the changing definition of the marital contract. As American life expectancy continues to climb, the concept of till death do us part is being tested by the reality of 80-year marriages. We are seeing a rise in sunset clauses within prenuptial and postnuptial agreements. These are provisions that automatically expire or trigger a renegotiation of terms every 10 or 20 years. Divorce attorneys are now acting as long-term contract managers, helping couples update their marital agreements to reflect changing career paths and the accumulation of wealth over nearly a century of life. Another major trend is the weaponization of the final sale of the marital home. In 2026, the real estate market is intrinsically linked to the divorce industry. When a judge orders a house to be sold and the proceeds split, the choice of a real estate agent becomes a legal battleground. Attorneys often insist on court-appointed receivers or specialized divorce real estate experts who understand how to navigate the tension between two people who may not be on speaking terms but must agree on a listing price. If one party refuses to sign the closing documents, the attorney must file a motion for a leaser. This is a powerful legal tool where the court clerk is authorized to sign the deed on behalf of the uncooperative spouse. The cost of this single motion can range from $2,000 to $4,000, illustrating how the industry continues to extract value until the very last asset is liquidated. Step by step, the industry is also moving toward a more holistic or wraparound service model. We are seeing the rise of the divorce hotel or the dissolution retreat, where couples go for a weekend to work with a team of attorneys, mediators, and financial planners to hammer out an entire agreement in 48 hours. While this sounds efficient, the industry prices these at a premium, often charging $20,000 for the weekend. The potential outcomes are a faster resolution, but the high-pressure environment can lead to buyer's remorse, fueling a secondary market of legal malpractice claims or motions to set aside agreements due to duress. Looking toward the 2030s, the American divorce attorney industry is expected to integrate even more deeply with decentralized finance and global identity verification systems. As we move into an era of programmable money, we may see smart contracts that automatically trigger alimony payments or child support based on real-time income data from a person's digital wallet. This would theoretically eliminate the need for enforcement attorneys, but the industry is already pivoting to provide the auditing and programming services for these contracts. The lawyer of the future will be part coder and part arbitrator, managing the digital infrastructure of the American family. Furthermore, we must address the systemic push for reform. There is a growing movement in the United States toward mandatory mediation and the expansion of the summary dissolution process for a wider range of people. Advocates argue that the current system is an extractive machine that drains middle-class wealth. However, historical trends show that the legal industry is highly adaptable. Every time a new law is passed to simplify divorce, the industry finds a new layer of complexity, such as the valuation of digital reputation or the division of frozen embryos, to ensure that specialized legal counsel remains a necessity rather than a luxury. The industry is also grappling with the ethical implications of AI-generated legal advice. In 2026, the American Bar Association and state-level regulatory bodies are debating whether an AI can be held liable for a bad legal recommendation. If Elena uses a low-cost AI service that fails to disclose a specific tax loophole, who does she sue? This uncertainty is keeping the traditional, human-led law firm at the top of the food chain. People are willing to pay the premium for a human being who can be held accountable in a court of law, and who can navigate the emotional nuances that a machine simply cannot grasp. In this 10-part masterclass, we have traveled from the initial consultation and the dynamic disclaimer to the digital hunt, the international chessboard, and the financialization of domestic conflict. We have seen how the billable hour drives strategy, how technology is both a tool and a weapon, and how the industry survives by turning heartbreak into a structured, multi-billion-dollar administrative process. The American divorce attorney industry is a mirror of our society's values, valuing property rights, due process, and the protection of the individual, but doing so at a cost that is often staggering. As we conclude this deep dive, it is clear that the divorce industry is not just about ending a marriage, It is about the complex, expensive, and necessary work of reorganizing a society one household at a time. Whether through a collaborative boardroom, a private judge, or a digital platform, the machinery of divorce will continue to evolve, reflecting our technology, our economy, and our changing human relationships. This concludes our educational overview of the industry. Thank you for joining this masterclass. Stay informed, stay objective, and always conduct your own due diligence in the face of the American legal system.